Welcome to the latest Evershed Sutherland Legal Insights podcast.
Welcome to this podcast, which is part of a series of podcasts on the UK Digital Markets Competition and Consumers Act 2024, or the DMCC. In this podcast, we will be comparing the new digital markets competition regime with the EU's comparable regime introduced through the EU Digital Markets Act in November 2022. My name is Julia Woodward-Carlton. I'm a partner in the Competition, Trade and Foreign Investment team at Evershed Sutherland, and I'm delighted to be joined today by my colleagues Marjolein De Backer, a partner in our Brussels competition team, and Annabel Borg, a legal director in our competition team in the UK. So to kick off then, perhaps I can start with you, Marjolein. Let's start with the EU. Please could you provide us with an overview of the EU Digital Markets Act?
Sure, thanks, Julia. The aim of the Digital Markets Act, or the DMA, is to make markets in the digital sector fairer and more contestable. In the same way as the DMCC, in fact, the DMA aims to ensure that markets, for example, don't tip over to one player. And it does that by setting some rules of the road ex ante rather than needing to intervene ex post in antitrust investigations. But that said, actually, the DMA's do's and don'ts, they are largely based on conduct that has previously been scrutinized under competition law. So there is some linkage there. Now, if we look at how the DMA tries to achieve its goals, it identifies large digital platforms, which it then designates as gatekeepers for certain services which fall within the DMA's scope. And they must comply with a number of obligations and refrain from adopting certain practices. Both core platform services as well as these do's and don'ts are listed in the DMA. And the European Commission is the enforcer of the DMA, and it became operational in May 2023.
So looking then at the DMA, how does the Act identify gatekeepers?
Yeah, so actually it identifies gatekeepers on the basis of three qualitative criteria. And they are: one, having a significant impact on the European internal market; two, providing a core platform service that acts as an important gateway for business users to reach their end users. And these platforms need to enjoy an entrenched and durable position. Digital platforms must use these criteria to self-assess whether they fall within the scope of the DMA for certain core platform services. And that list of core platform services is actually exhaustive, and it covers, let me just mention them, intermediation services, search engines, social networks, video sharing, interpersonal communication services, operating systems, cloud computing, and advertising. And there is a presumption in the DMA that a company falls within the scope of the gatekeeper definition, always for specific core platform service, if certain quantitative thresholds are met that are linked to these three qualitative thresholds that I mentioned before. And the quantitative thresholds relate to revenue, capitalization, geographic reach within the EU, and the level of active end users and business users. And as soon as a platform considered meets these criteria, it has to notify the European Commission, who will then look at the notification and take a designation decision. The designation decision will specify one or more core platform services that are relevant for each gatekeeper. Now, the European Commission also has the possibility to actually designate gatekeepers, even if they do not meet any of these criteria. And then, for example, the Commission will look at examples of network effects or conglomerate structure, but that hasn't happened thus far yet. But the Commission has designated quite a number of gatekeepers, about 7 companies, and those designations related to 24 core platform services.
Thank you, Marjolein. So, I mean, interesting. Obviously, the UK is somewhat behind, but fast catching up. So, Annabel, if I can turn to you, if I could ask you to say a few words about how is it that the UK regime compares with the EU DMA in terms of its purpose and who it applies to?
Yes, thank you, Julia. So the aim of the UK digital markets competition regime is very similar to the DMA, except that its focus is to make UK digital markets fairer and more competitive, as you would expect. The regime will apply to firms which have what the DMCC refers to as strategic market status, or SMS. And like the DMA, the DMCC contains 3 criteria which a firm must meet to be designated as having SMS. It must have 1, global turnover exceeding £25 billion, or UK turnover exceeding £1 billion, 2, it must have a substantial and entrenched market power. And 3, a position of strategic significance where digital activity is linked to the UK. However, unlike the DMA, digital platforms will not need to self-assess to determine whether they meet this criteria. Instead, the UK Competition and Markets Authority, the CMA, will undertake an investigation to determine this. Also, unlike the DMA, there are no quantitative thresholds to determine if a firm has substantial and entrenched market power or a position of strategic significance. Instead, the CMA states that it will conduct an evidence-based assessment to determine if these conditions are satisfied.
And thank you, Annabel. And for a firm to be designated under the DMCC as having significant market status, do they actually need to be based in the UK?
No, they don't. It is sufficient that either their digital activity has a significant number of UK users, the firm carries out business in the UK in relation to the digital activity, or the activity is likely to have an immediate, substantial and a foreseeable effect on trade in the UK. However, this is likely to be a low hurdle to overcome, given the wide discretion afforded to the CMA.
Thanks, Annabel. Marjolein, you've talked about gatekeepers. Under the DMA, can you say a few words about the kind of rules that gatekeepers in Europe will have to follow?
Sure. So gatekeepers, they actually will need to comply with a broad set of predefined and also untailored obligations and prohibitions that are set out in the DMA. They include, for example, provisions such as third-party interoperability, providing data access for customers, easy unsubscribe options, stopping pre-installed software, and prohibiting unfair practices such as favoring their own products over competitors, which we call self-preferencing. In addition to those specific do's and don'ts, gatekeepers also have an information obligation about their M&A activity, but we'll come back to that a little later. And gatekeepers also have to create a DMA compliance function, and that function actually needs to meet some quite strict criteria, such as, for example, direct reports to the board.
And Annabel, what about under the DMCC? How is that different?
Yeah, so under the DMCC, the CMA may also impose conduct requirements on firms designated as having strategic market status. However, unlike the DMA, these conditions will vary depending on the firm and their designated activities, so they'll be more sort of bespoke. In terms of the actual types of requirements, we expect those to be similar to those in the DMA, so, you know, stopping self-preferencing, etc. Under the DMCC, SMS firms will have to publish compliance reports setting out how they are complying with their conduct requirements.
And sort of on the topic of compliance, Marjolein, what types of powers does the European Commission have to ensure that gatekeepers, in fact, comply with the requirements of the DMA?
Yes, Julia. So in the first instance, actually compliance is a burden for the gatekeepers. So once they are designated as a gatekeeper, they have 6 months to submit a detailed compliance report that outlines how the gatekeepers intend to comply with each of the obligations under the DMA. And in fact, based on that compliance report, the Commission will also have a dialogue with other stakeholders. And the Commission has in fact already opened a number of non-compliance investigations and has also taken investigatory steps without formally opening a non-compliance probe in relation to other cases. So if the Commission at the end of these probes were to conclude that there is non-compliance, then they can actually impose fines of up to 10% of the company's total worldwide turnover, and that could possibly be combined with periodic penalty payments in case a gatekeeper does not comply with a decision that is then adopted under the DMA. Further, actually, if gatekeepers were to circumvent the DMA or are repeatedly found to not comply with the DMA, these fines can increase to up to 20% of global turnover. And the Commission can at that point also impose behavioral or structural remedies, which, at least in theory, under the DMA would allow for breaking up existing groups. But that's probably more theory than reality.
So pretty extensive powers of enforcement. So Annabel, will it be the same for the CMA with powers under the DMCC for the UK?
Yes. So like the Commission, the CMA will be able to impose large fines of up to 10% of their global group turnover for non-compliance with the DMCC. However, it will also be able to penalise individuals, which adds an extra layer of accountability. So each SMS firm must appoint a nominated officer who is effectively a senior manager to verify that the firm has complied with its requirements under the DMCC. The CMA can fine a nominated officer if, for example, the CMA considers that the individual failed without reasonable excuse to prevent the firm from complying with those requirements. In addition, the CMA can disqualify directors. The CMA will also have the power to use what the DMCC refers to as a final offer mechanism. This can be used to resolve breaches of conduct requirements relating to unfair payment terms. Furthermore, the CMA will be able to conduct targeted pro-competition interventions in relation to SMS firms, and these can be used if there are factors relating to a digital activity which are having an adverse effect on competition. The CMA will have the power to impose various remedies on SMS firms to mitigate such an effect, such as structural and behavioural remedies, like Marjolein mentioned.
Thank you. I suppose that leads us on nicely. So one of the points we haven't yet covered is in relation to provisions under both the DMA and the DMCC relating to mergers and acquisitions. So I'm going to ask each of you, starting perhaps with Marjolein, are there any specific provisions in relation to mergers and acquisitions in the DMA?
Yes, there are in the DMA, but it's actually only limited to an information obligation, as I just referred to briefly earlier. So gatekeepers must inform the Commission of every transaction where the merging entities or the acquisition target provide a core platform service, any other service in the digital sector, or services that facilitate data collection. But in practice, that actually means that they have to inform the Commission about any M&A activity prior to implementation of any deal. Now, the DMA interestingly mentions explicitly that this information can be used to inform the EU member states to refer cases that would otherwise not be reportable anywhere to the European Commission for review under Article 22 of the EU merger regulation. But the EU courts may actually put a hold to the use of Article 22 for this purpose, and we will know that in early September when the European Court of Justice will actually make a judgment about the use of Article 22 for non-reportable deals. And if the European Court of Justice puts a stop to the use of Article 22 in this way, then the M&A information requirements under the DMA will be of much less value.
And Annabel, what about under the DMCC?
Yeah, so under the DMCC, there are also special provisions relating to M&A. So SMS firms will be required to report all of their M&A deals to the CMA where two conditions are met. Firstly, where they acquire a certain proportion of shares or voting rights in a company which is active in the UK. And secondly, where the value of that holding is at least worth £25 million.
Thank you. So now as we come towards the end of this episode, can I ask each of you for your final thoughts on the DMA and the DMCC, and really to give some thought as to what their potential implications are going to be going forward? Marjolein.
Sure. So I think to start with, the new digital regimes, both in the EU and the UK, actually represent a significant step change in the regulation of digital platforms and ensuring fair competition. So while both the Commission and the CMA will continue to be able to use their traditional competition powers to enforce competition in digital markets, the new regime should, in theory at least, reduce the need for such lengthy and time-consuming investigations. And certainly the DMA is being used by default, in the sense that if a situation can be addressed under the DMA, it should be, and it should not be looked at under antitrust rules anymore within the European Union. And also the European Commission has been really quick to come out with non-compliance investigations, but of course it still remains to be seen whether these will get concluded quickly and whether in practice we will actually see more and new activity in markets where gatekeepers are present.
Whilst the DMA and the DMCC introduce important obligations for gatekeepers and SMS firms respectively, they also provide opportunities for smaller platforms, small and medium-sized enterprises, as well as startups to thrive. However, it will be crucial to carefully monitor their implementation in order to strike the right balance between fostering competition and innovation while avoiding unintended consequences.
Well, thank you so much, Annabel and Marjolein, for sharing your insights on this very, very interesting area. And it's really quite clear from what we've heard from you both that while the UK and the EU are striving for fair digital markets, their paths diverge in really quite interesting ways. And so it will be interesting, and we'll all be watching to see how the two regimes develop. And I think our current expectation is still that the DMCC will come into force sometime before the end of this year. So that brings us to the end of this podcast, and I want to thank all of you for listening. Please do also catch up on our previous podcasts in this series if you've not already had the opportunity to do so. Thank you.
Thank you for listening to the Evershed Sutherland Legal Insights podcast.